92, subsections 1b of the Trademarks Act 1994. My Lord, the short point set out very clearly, I hope, in the papers before the court is whether or not that subsection applies to the sale of counterfeit goods and to adopt the definition of counterfeit goods in the judgment of the Court of Appeal in the sense of the manufacture of the goods and the application of the relevant sign or mark to the goods being unauthorised by the trademark proprietor. The construction which the appellants submit should be put upon that section is that the use of the expression such a sign in subsection 1b should be interpreted as a reference to a sign which has not been applied with the consent of the trademark proprietor.
Yes.
My Lords, there are no explanatory notes to the 1994 Trademarks Act. There was, however, an explanatory note to the Copyright and Trademark Offences and Enforcement Act of 2002. And can I ask, my Lords, to go to the Authorities Bundle, Volume 1, at tab 3, page 193. We've included here the explanatory notes to the bill. I apologise for that, but I can indicate, as is accepted by the Crown, that in fact the explanatory notes to the Act, which was enacted in the following year, are in the same terms. And the Act introduced various procedural provisions which were then introduced into the 1994 Act, and by way of background, set out the purpose of the provision, indicating that goods, packaging, or labels bearing a trademark that has been applied without the consent of the trademark owner, i.e. counterfeit goods, and articles that are specifically designed or adapted for making unauthorised copies of a trademark for use in such goods and other material. And if one then goes to paragraph 10 under the clauses, one sees essentially the same point made, that the sections are deemed to relate to counterfeit goods and articles for making them.
But can notes on a statute following the 92 Act affect the construction of the 94 Act, affect the construction of the 94 Act?
Well, it's my submission that in the absence of explanatory notes to the Act itself, the Court is assisted by reference to subsequent explanatory notes.
That's an extraordinary.
Is there any authority for that proposition?
No, there isn't.
I mean,
what it means is that if somebody was prosecuted between 94 and 2002, you'd come up with one answer and another answer afterwards. That can't be right, can it?
Well, it's my submission that given that this was an amendment to the original Act, that it is right to look at the purpose of the section as construed by the parliamentary draftsman when introducing further provisions into the Act, or the perceived.
But Parliament wasn't having an opportunity. I mean, wasn't addressing the relevant sections at all. It's just for the purpose of different provisions describing, is it, the earlier sections. That's all it amounts to.
I accept that. I accept that.
Well, it's I mean, the rationale of explanatory notes is that the legislator is deemed to have paid them some attention when it was actually enacting the relevant provisions.
Yes, it is perhaps an indication of the way in which the section was conceived as operating. Perhaps it goes no further than that. But it is in my submission, some indication.
It either goes somewhere or it doesn't.
Well,
I mean, you can't just, by putting it in different phrases, say that it's relevant.
Well, it's my submission that it is relevant and could properly be considered by the court. Can I just, moving beyond that point, go to the consideration that there has been of the operation of Section 92 in the higher courts. There are two authorities. Obviously, the principal authority, which we've referred to in the written materials, is the case of Johnston, which was considering a different point, but does have in our submission some very important observations about the perceived ambit of the criminal provisions. But we start with the case of S, which is at tab 15. S was an authority which was, the judgment was delivered by Mr. Justice Davis, as he then was, and it was an authority which was considering the operation of the statutory defence under subsection 5 and whether or not considerations of the human rights provisions should mean that subsection 5 should bear an evidential, the defendant should bear an evidential burden or a persuasive burden. And the court came down very clearly in favour of the latter of the two constructions. Can I just, during the course of the judgment, Mr. Justice Davis made certain observations about the construction of the section. Paragraph 10, the middle of that paragraph, implicit in the provisions of sections such as Section 92, is the objective not only of protecting the ownership rights relating to registered trademarks, but also of enhancing trade and promoting legitimate economy and providing consumer protection. And he goes on to make various further observations, including at the bottom in paragraph 11, reference to the agreement on trade-related aspects of intellectual property rights and the provision in relation to the criminal procedures. Members shall provide for criminal procedures and penalties to be applied, at least in cases of wilful trademark counterfeiting or copyright piracy on a commercial scale. And over the page, he goes on to indicate that the effect of that provision is that the member state shall provide for criminal procedures but are not effectively limited to such provisions when considering the criminal provision. Can I then just turn to the judgment itself, dealing with the question of whether or not there should be a persuasive or an evidential burden? One finds that at page 323 in the bundle. It's paragraph 48. And this is where the court sets out the reasons for holding there is persuasive burden. And I just want to draw the court's attention to number one. There are the factors which have already mentioned relating to considerations of policy, the purpose of the legislation, and the mischief at which it's aimed. These provisions of the 1994 Act are designed not only to protect proprietors of registered trademarks, but also to protect and safeguard consumers from the activities of counterfeiters. There is a very important element of consumer protection here. We consider this a point of significance. So it's our submission that as construed by the Court of Appeal in this case, the provisions are designed to protect both proprietors and consumers from the activities of counterfeiters. Now, with that in mind, can I just then turn to the decision in Johnston, which is at tab 13. S was decided after the decision of the Court of Appeal in Johnston, but before the decision of the Judicial Committee of the House of Lords. And Johnston was, in Johnston, the House of Lords were considering the relationship between the civil infringement provisions set out in sections 9 to 12 of the Act and the criminal offence provision set out in section 92, and held that there had to be infringement contrary to the civil provisions in order for there to be criminal liability. That's the ratio of the case. Lord Nichols started by giving an overview by stating, "My lords, counterfeit goods and pirated goods are big business." And then I'm at page 272, my lords. They account for between 5% and 7% of world trade, estimated to cost the economy of this country £9 billion. Counterfeit goods comprise cheap imitations of the authentic article sold under the trademark of the authentic article, as with imitation Rolex watches. And he then goes on to consider the difference between that and pirated goods and bootleg goods. Over the page, under the heading Trademark Use, Indication of Trade Origin, page 724 in the bundle.
274, yep.
274, I'm sorry.
There were.
He indicated this in the second sentence. The essence of a trademark has always been that it's a badge of origin. It indicates trade source, a connection in the course of trade between the goods and the proprietor of the mark. That's its function. That's the character. Use of this character is an essential prerequisite to infringement. He then considers the background to the Act, or the criminal provision, paragraph 26, page 277, bottom right, and points out that the predecessor of Section 92 was Section 58A of the Trademarks Act 1938, which had been inserted, and makes the point in the middle of that paragraph. Section 58A made the fraudulent use of a trademark an offence. Difficulties arose in practice in providing the necessary intent in cases where at the point of sale the trader described his counterfeit products as brand copies or genuine fakes. Section 92 avoids this problem. In particular, intention to infringe a registered trademark is not an ingredient of the offence. Instead, Section 92 focuses simply on unauthorised use of a sign identical to or likely to be mistaken for. And the point being made there is that the specific element of mens rea in the earlier section had been removed by the new section, Section 92, because of the particular difficulty which is referred to there. And then if I can then move, please, to the way in which the court dealt with the point which had arisen in S concerning the burden of proof in the statutory offence. And in effect, Lord Nichols agreed with the decision in S. Page 282, paragraph 52. And this, in my submission, is an important indication of the way in which the criminal provision has been construed, or should be construed. I turn to Section 92. Counterfeiting is fraudulent trading. It is a serious contemporary problem. Counterfeiting has adverse economic effects on genuine trade. It also has adverse effects on consumers in terms of quality of goods and sometimes on the health, safety of consumers. And then the last sentence in that sub-paragraph, protection of consumers and honest manufacturers and traders from counterfeiting is an important policy consideration. And the point that we make is that in construing the statutory defence, the court has placed emphasis on what it perceives to be the policy of the Act, which is protection from counterfeiting. It's our submission that absent that consideration, it may well have been that the statutory defence would not have required the persuasive burden to be on the defendant, but it would have been the evidential burden. It's an important part of the reasoning of the court on that point. It was obiter so far as the decision...
What is precisely meant by counterfeiting? If somebody applies the registered trademark to goods and then it's pointed out or they realise that the goods are defective in quality, they wouldn't allow those goods knowingly to go on the market. And yet, on your analysis, because counterfeiting, as you construe it, only applies to the original act of applying, irrespective of what subsequently happens, wouldn't be an offence. But it would seem to me that in terms of quality of goods and possibly the health or safety of consumers, it's just as detrimental or deleterious and probably just as wrong if somebody in those circumstances gets hold of the goods and puts them on the market as genuine goods, or goods which carry the genuine imprimatur of the registered trademark holder.
My Lords, there are 2 points I'd like to make in answer to that. The first is that the question was what is meant by counterfeiting. Can I just take my Lords to, which is the first paragraph of the speech of Lord Walker. And he starts again by reference to counterfeiting. And in the middle of that paragraph, he states this: counterfeiting, piracy and bootlegging are not exact terms, but all involve deliberate and generally fraudulent infringement of various intellectual property rights, so on. And then it's this sentence: counterfeiting is generally used to include unauthorised sale under a well-known trademark of goods not made or authorised by the proprietor of the trademark. And that is exactly the definition which we would say should apply to section 92.
Treating authorised as referring only to the original act of manufacture rather than to the putting on the market.
Yes, that's right.
The market is virtually by definition a market in goods in relation to which the trademark is absolutely genuine.
Yes.
Because it's been applied with the consent of the proprietor, but the sale is not authorised. I mean, all of this really depends on whether you are, on what the words "such a sign" refer back to.
Yes.
In sub B, the words "such a sign" could mean one of 2 things. One, the sign that's in the trademark register, which is what Lord Justice Davies thought. Or 2, a counterfeit sign. Now, A, which is what such a sign refers back to, is neutral as to whether it's counterfeit or not, isn't it? The counterfeit character of a trademark doesn't depend on the matters set out in A. It depends simply on the absence of the proprietor's consent. And it might be said that such a sign doesn't refer back to the language which refers to the absence of the proprietor's consent. That is an independent precondition for the application separately of each of A, B and C.
Yes, I understand that. I mean, that's the difference between the parties.
Yes. But what is wrong with that analysis?
Well, it's the use of the expression "such a sign." It's our submission that the reasonable way to construe the expression "such a sign," because such a sign refers back to the provisions of subsection 1A, and subsection 1A is conduct which is carried out without consent. The lack of consent is implied into...
respect, because subsection 1A is simply referring to the affixing of the sign. The without the consent is not a requirement of 1A, it's a requirement of the preambular words, and it applies separately to each of them.
It applies, my Lord, I absolutely accept that. It applies separately to each of them. We can agree about that. But the use of the expression "such a sign," my submission, our submission, must mean that it's a sign which has been applied, applying the governing provision without consent.
Surely all it means is a sign which is identical to whatever you find in the registered trademark registry. I mean, a sign identical to a registered trademark is a sign.
Yeah.
You go and look at what is registered under the Act,
Yes.
and they'll ask, are these goods bearing a sign which is identical? It's completely irrelevant how and why they're bearing them, because under B, all you have to do is sell or let for hire, etc. That sign for profit or with intent to cause loss and without the consent of the proprietor.
Yeah.
And then you have a defence of reasonable care at a later point.
Yes, it's a narrow point, and it's simply this. Given that the words "without consent" apply independently to each of the subsections, the question is whether the specific use of the expression "such a sign" imports a sign which has been applied without consent. or whether it doesn't. I mean, that's the...
That means that without the consent applies twice when you're operating B.
Yes, it does.
And you're not just, such a sign is not just referring back to the latter part of A, it's referring to the whole of the preceding.
You say such a sign means a sign to which A applies.
Yes.
Where an offence has been committed under A, effectively.
Yes? That's right. Yeah.
Well,
that's right.
It's a little difficult to read it that way, isn't it? Such a sign obviously refers back to A. There's not much doubt about that. If you go back to A, which kind of sign is it talking about? Answer a sign identical to or etc.
Yeah, I mean, those are the two competing.
Yes, fair enough. Okay, it's one or the other.
It's one or the other. It's our submission, however, that when construing it, one does have to look at the purpose of the legislation. And as a matter of fact, to take the double consent point, if one goes to the pithy definition of counterfeiting in Lord Walker's speech, to which I've already referred the court, counterfeiting is generally used to include unauthorised sale, so in other words, sale without consent, under a well-known trademark of goods not made or authorised by the proprietor of the trademark, which is...
I mean, under your definition, if you take Lord Walker's definition, A wouldn't be an offence, because his definition seems to require unauthorised sale, whereas A doesn't require sale, it just requires unauthorised application of a sign identical to a registered trademark.
Yeah,
I mean, you can't read language in a ambulatory paragraph in a statute as a definition, can you?
Well, what he says is it includes sale under a well-known trademark of goods not made or authorised.
Surely the problem is this, that looking at generalised comments, and he says in general, even from Lord Walker, is not really going to assist in construing this statutory provision, is it? I mean, in the end, we have to look at the statute in the way that you've been doing with my Lord Manson, Lord Hughes.
It's our submission, and the court will see this.
It makes it a very short point. I appreciate.
Yeah.
Doesn't the fact that it's a short point and people may disagree with it, each other on it, doesn't necessarily mean that one's going to be helped by going into highways and byways, does it?
No, I hope we're not. I mean, I hope by attempting to look at the purpose of the criminal provision.
I understand that, yes.
Which lies behind
That's a fair point.
It's my submission, it is. Can I just take this submission in a slightly different way? Because I know there's an argument about whether or not the court should refer to the parliamentary debates. I've taken the court's explanatory notes. But and can I just put that to one side for a moment? Just assuming for a moment that the court would agree that it would be relevant to seek assistance for the parliamentary debates. It is my submission that there is little doubt that what Parliament intended was that this provision should be confined to the sale of counterfeit goods. And if that were right, the construction which we advance for this subsection must apply in our respectful submission. There may, however...
Are you going to be able to show, if we go into the parliamentary debates in any detail, Mr. Blackton, you'll have lots and lots of references to counterfeiting,
yes,
and to the evils of it, far too much of it about, bad thing, needs to be criminalised. That's a different proposition from this section should be confined to counterfeiting in the sense that you have carefully used it here.
Yes.
Do you say that you're going to find that distinction in the parliamentary discussion?
No, I don't. I don't, except that there is, in my submission, a clear distinction to be drawn between counterfeiting as it is understood, fake goods, as explained in Nichols, by Lord Nichols, sorry, and the more general proposition, which underlies the Crown's interpretation, which is that goods which are simply sold without consent, even though they are, to all intents and purposes, authentic goods. That's the way that the Crown would construe it. But can I just make a further point, just for the Court's consideration? And this is the reason that I referred to the parliamentary debates. It may be, and I concede this, that the removal of the element of mens rea in the original section 58A, or it may be that that element of mens rea was in fact what gave the previous section or limited the previous section to the trade in counterfeit goods. It may be, and it may be that the removal of that mens rea element had the unintended consequence that counterfeit goods were no longer covered by section 92. That is one construction of what happened. What is clear, however, is that when Parliament was debating it, that was not the intention of Parliament. It may be that the effect is it clearly gives rise to the argument which the Crown have, that this is how it should be construed, despite the fact that we know that in general, if at all, the trade in grey market goods is not the subject of criminal prosecution. But that is a further consideration, and it's why in my submission, when looking at the construction of the section, the court should look at what is intended. And one gets the intention or the purpose of the criminal provisions, not just from Parliament, but indeed also from the observations of the House of Lords in the case of Johnston.
Sorry, can I just understand, maybe the removal of section 58 had the consequence that...
The consequence that the previous section was intended to, and did cover counterfeiting because of the mental element.
Yes.
No longer covered it.
No longer covered it.
Confined to it. You're not saying that 92 doesn't cover the goods. You're saying it was extended beyond, unintentionally extended beyond.
Yeah. By removing them, it may be that what limited the criminal offence to counterfeiting was the mental element. By removing that specific aspect of the mental element, one has the unintended consequence that the court then has to look at the construction of the section to see whether or not it can be extended to counterfeit
And
goods.
you end up inadvertently including grey market goods when nobody meant to. That's your case.
So, what? But if that's right, what do we do? Correct Parliament's mistake?
What the court should do in my submission is to construe the section, and it is capable of construction in a way.
I see. So what you're really saying is that the removal of section 58A has given rise to a bit of ambiguity, which we should clear up in the sense.
Yeah, that's a very neat way of putting it. Thank you very much, Ollie. But can I just return to, I said there were 2 points in response to my Lord Mance's observations about the undesirable consequences of the construction of the section. And the second observation comes from the observation of the Court of Appeal, that where does this leave goods which are produced with the authorisation of the trademark proprietor, but then are defective and therefore not sold. The answer in my submission to that is that defective goods, the sale of defective goods can be perfectly properly dealt with by alternative provisions. What this Act is dealing with, health and safety.
They can be prosecuted for what? Under what? Under safety rules and that.
It's under safety rules, under health.
Assuming there are some.
Yeah. Well, but that would be the relevant.
Supposing they're not dangerous, just not good enough to satisfy the manufacturer, satisfy the trademark holder.
Well, consideration would have to be given to whether or not they could be prosecuted under alternative legislation. And the broader point that I make in relation to that is that if we're right, and the purpose of this is to prevent the sale of counterfeit goods, meaning goods which are fake, produced by a different manufacturer, my submission, the particular considerations in relation to the problems which may arise from a batch which has particular problems should not be brought within that specific criminal provision.
Is the answer the same to the deliberate overrun point, or is it different?
Well, the deliberate overrun point is there's more than one answer to the deliberate overrun point. Well, if the manufacturer, because it does come back to the question of consent. I mean, various examples are given in the respondent's reply. But if, in fact, the goods have been produced by the manufacturer in excess of the order, then they wouldn't have been produced with the consent. It's a question of one has to go back to the original consent.
You couldn't tell which was which. At least one of the points that's made is that you couldn't tell which was which.
But that's
just a problem of proof.
It's a problem of proof which crops up in these cases, and it's not hitherto being considered to be a problem for the enforcement of this section.
Right.
My submission. It may well become a problem if we're going to be extending the section to deal with grey market goods. I can understand that, but that's the consequence of it.
30 minutes.
Can I just refer briefly to the observations of the writers of Curley, because they're relevant to a limited extent, but what they illustrate is, and this is the difficulties which arise from the interpretation of the section which is advanced by the respondent. It's at volume 2, tab 24. And just these short passages, the first, page 499, bottom right. It's chapter 22 in Curley. And the third sentence is primarily aimed at counterfeiting, but as will be suggested below, it seems that the definitions of the offences created are so broad that many other kinds of behaviour will or may also amount to a criminal offence. And then they give examples, page 500, bottom right, paragraph 22, 7, chapter 22, paragraph 7. The final paragraph of that, the final sentence of that paragraph, this will avoid the problems which have arisen in some cases under the Trade Descriptions Act where defendants have avoided liability by selling counterfeit goods at stalls bearing a warning that the goods are fake. So that's a reference to the particular issue which arose in Johnston, and which was the basis for the removal of the mens rea element. And then at over the page at 501, paragraph number 12, the penultimate sentence, a defendant who gives no thought to whether his acts would infringe but had no reason to believe that they did will be in danger of committing an offence without any ill motive at all. For this reason alone, it appears that section 92 goes well beyond counterfeiting. So what's being pointed out there is that one of the effects of the construction which the respondent urges, which does take the offence beyond counterfeiting, is that if there's no requirement for the Crown to prove counterfeiting, when it comes to the statutory defence, the defendant has very little by way of protection. There are problems with the ambit of the statutory defence. And the similar point is made at, over the page, 502, 14, by reference to section 92. The fact that the marks need not be identical and may be merely similar is another reason why section 92 extends well beyond counterfeiting. The requirement that the marks be absolutely identical would allow the section to be avoided too easily by counterfeiters merely by a trivial change to the mark. And so on. The point which one derives from this observation is that the criminal section is we would submit, overbroad on the construction which is advanced here. That's all I wish to say about Curley. Can I just deal briefly with the question of the headnote, which is a point which is raised by the respondent. The respondent relies upon the headnote, unauthorised use of trademark. It's our submission that that is of very limited, if any, assistance to the court. For example, the headnote does not refer to the unauthorised sale, because it's in such general terms, it's the use of the trademark. Originally, the section, and I hope the court has seen the original clause, which was clause 86, which has been submitted to the court. Originally, what became Section 92 was an offence by somebody, a person commits an offence who fraudulently applies to goods or their packaging, etc., and fraudulently had the specific definition in subsection.
Sorry, where do we find this again?
My lords, did this document find its way to the court? It was an additional document.
Yes, you've got two different. Are they successive versions of the bill behind the letter which came?
Yes. Yes.
8th of June.
Yeah, that's right.
Yep.
That's right. It's just this point that subsection 4.
I very efficiently brought the letter, but not the enclosures. What do they look?
Well, can I just make the point, and it's a very short point.
Here's one bill, fortunately, and here's the next one,
I looked at them.
which doesn't.
We have
I see it. No, you don't.
we have spare copies. I mean, it was originally going to be, the original head note was fraudulent use of trademark. Fraudulent was given a particular definition in subsection 4, with a view to gain or with intent to cause loss, and without the consent of the proprietor of the registered trademark. So it was a narrow definition of fraudulent, but nonetheless the word fraudulent was used. One can see from the parliamentary debate that there was objection to the use of the word fraudulent, which was said to be over emotive, and it was therefore, and the section was therefore redrafted, but with, in fact, the same effect, because the provision, the governing provision in relation to the lack of consent, then became the determining provision for the section as a whole.
Effectively, what was subsection 4 goes into the
That's right.
early words
That's
of
right.
92, doesn't it?
That's right.
And I can quite see the point of intent to cause loss, but virtually every trader will have a view to gain, won't he? Yeah.
It adds really nothing, my submission. The only really meaningful distinction between civil infringement and the criminal offence is the statutory defence.
Yeah, so it's reasonable grounds.
There's a burden. It's a reasonable belief in infringement, which is civil infringement.
Yeah.
That's made clear by Johnston, and in fact, it's made clear by the terms of the Act. Section 104 defines infringement. So the point I'm making here is that the head note ultimately doesn't assist really either side in the construction of this section. It was relied upon by the Court of Appeal, formed quite an important part of the Crown submissions, but ultimately the head note...
Sorry, why doesn't it assist? I mean, it's the ultimate phrase which is used.
But it's... Yes. It was originally going to be called fraudulent trading.
But fraudulent was given a very artificial,
precisely,
and rather limited.
But if let's say that the word fraudulent had been retained in the Act, as opposed to being amended, then arguably we would be relying upon that element of it, despite the fact...
Slightly inconsistent with your earlier argument, and this is actually part of the Act. What they chose when they reformulated and stepped back was a language which you don't like, you say is we should jettison as irrelevant.
Well, it's unauthorised use of trademark. It's a very general description. In fact, of course, on our submission, the criminal offence in Section 92 is precisely to do with the unauthorised use of the trademark. That's what it's all about. So we would submit that in fact, the head note, if it assists either side, arguably assists our submissions.
Can you just give me the number of the paragraph where the Court of Appeal referred to the head note?
I'm terribly sorry, my lord.
Which paragraph did the Court of Appeal
Which paragraph the Court of Appeal?
allow on the head note?
I'm sorry, I don't have that.
No, well, don't worry.
I don't have that in my fingertips. It may be that somebody
don't worry.
Can help, but it is referred to in the Court of Appeal's judgment. I think I'm right. I know it was certainly part of the...
Is it 13?
Yes, just give me a moment.
making the point that it's to give effect to the directive. Well, it is, but the criminal provisions, of course, are not
Yes.
not transposing the directive, are they? They're additional.
15 quotes it. It doesn't say anything about it.
Yes, it's paragraph 15, my lord.
No,
13.
15
quotes
quotes it. It doesn't rely on it.
Okay.
I'm terribly sorry. Maybe I misremembered. I certainly it's always been part of the Crown submissions.
But what about paragraph 21? I think you are right. They think that your interpretation is flatly contrary both to the heading and much more
That's
importantly
right,
to
yeah.
the wording.
Yep,
Yes, flatly contradictory.
Thank you.
Yeah. All of our submissions were flatly contrary to authority. It appears.
Well, you say it's not flatly contrary to the heading.
Yeah.
Yeah.
We've also, can I just move to one further submission, which is in our stated case, and which is the question of whether or not the section should be construed consistently with Article 1, Protocol 1 to the Convention. It's the disproportionate interference with the right to the enjoyment of private property. I hardly need to elaborate on that before this court. But it's our submission here that whereas in the Tesco case, the balance, this is the submission in the Tesco case, and there it was held that the balance was between the rights of the different traders, the rights of the manufacturers of the goods on the one hand, and the rights of the parallel importers on the other hand. Here it's our submission that the balance is between the rights of the trademark holder and the parallel importers, but between the rights of the trademark holders and the means employed by the state to criminalise the trade in counterfeit goods. And in our submission, in order to be construed consistently with the defendant's rights under A1P1, it should not be extended, the section should not be extended beyond counterfeit goods. And if that is a legitimate aid to the construction, we pray it an aid for the...
But what do you say is the relevant property? If the relevant property, the only relevant property has got to be the property in the actual goods.
Yes.
But they have no property in the trademark, which is capable of being infringed under A1P1.
No, of course, it is the property. It is the property in the goods, but of course.
Well, no one's stopping you erasing the trademark if it's no longer something which is entitled to be used.
No, but it's quite right. It's the trade in it's the property in the goods which are being sold by the parallel, dealt with by the parallel importer. But it's the consequences of an interpretation of the section which takes it beyond the trade in counterfeit goods.
In what sense do you say that the only proprietary right which your clients have, namely in the goods themselves, is infringed by their being unable, as in a matter of civil law they would be unable in any event, to sell them without removing the trademark?
My point is a different one, if I've understood my Lord's question, which is that the question in issue here is whether or not the full weight of the criminal law...
No, surely, if you're running a proportionality argument under
Yes.
the Human Rights Act, it must apply to the civil law offence as well. You can't be saying that somehow the Human Rights Act only strikes in when we're considering the criminal law.
Well, it obviously it doesn't solely, and the decision, it's a first instance decision, but it's a decision of some weight in the Tesco case, is against me on this point. So my submission is that it should be. When one considers the criminal provision, one is dealing with a different balancing exercise. The proportionality should be considered in a different light, precisely because of the consequences of a conviction for a criminal offence, maximum sentence of 10 years imprisonment.
Speaking for myself, I understand why there's a different proportionality balance between the property and the risk of criminal prosecution and the property and the risk of civil action. But what's the property? You can't sell them with the trademark on them anyway, can you?
Well, I'm sorry. I
mean, that's why I said that surely you've got to attack the civil offence, because to say that you've got some relevant property when it's a civil offence strikes one as rather odd.
It'd be unlawful to sell them, wouldn't it? On any view.
Yes.
Whichever of the various categories these things fall into, it's unlawful to sell them.
Yes.
So what's the right of property that is infringed under A1P1?
But if the property has been manufactured with the consent of the trademark proprietor and comes into the hands of the trader, the parallel importer, whoever it happens to be, he buys them, so he has them in his possession. At that point,
92(1)(c) specifically refers to paragraph B at the end. Slight sort of difference in tone. I don't know if there's anything in this, but 92(1)(c) says, if you have in your possession, etc., goods which if you do anything with intention to do something which falls within paragraph B. So paragraph C clearly links to paragraph B. Paragraph B is there anything in the point that if you were right, paragraph B at the end would refer to paragraph A rather than saying such a sign? Wouldn't it to be like paragraph C, say, which infringes paragraph A?
well, that
Isn't the slight change of tone between the end of B and the end of C slightly against you? Or is that too subtle a point?
well,
Just a bad point, perhaps?
Our submission would be that when one looks at the terms of paragraph C, one has to import into paragraph B the lack of consent which applies to paragraph A.
Well, no, I see that. But you do, at the end of C, have to import lack of consent because it wouldn't be an offence under B. But my point is that if the draftsman adopts that means of bringing in the non-consent,
No, I understand.
then maybe one was expected to see the same technique at the end of B.
I understand that point, but that doesn't, in our submission, destroy our point about the use of the very particular expression, such a sign. Can I just finish, really, with just one submission which arises from my learned friend's, the respondent's respondent's printed case, which is this. The respondent submits that on our construction, subsection 2, subsection B, which subsection 2 of section 92 deals, we would submit, with the creation of and the use of counterfeit packaging, business paper, invoices, and so on and so forth. The Crown submission is that on our analysis, in other words, the linking between B, subsection 2B and subsection 2A, would mean that goods which are in which a counterfeit or a genuine packaging was used to sell counterfeit goods would not be caught by subsection B. That's correct. That does the Crown's analysis of that is correct. However, it's our submission that goods which are sold with genuine packaging but are counterfeit would almost invariably amount to offences under the Fraud Act. They would amount to other offences, and it would be unnecessary to extend subsection 2B to such material, because this subsection is to do with a separate subject of counterfeit packaging and ancillary.
Just remind me, the Fraud Act came in when?
Well, the Fraud Act,
So
it would have been an offence also under the previous 1968 Theft Act as well.
Would it? Yes.
My Lords, those are my submissions, unless there are any other.
Thank you very much indeed, Mr. Blackland. Mr. Henry. Mr. Martin.
No. I'll move the thing.
If you want to reorganise yourselves, don't.
If I may.
Of course you may.
Yes, that's probably easier, isn't it? And I can give you all those. My Lords, Mr. Blackland has addressed you on the construction of Section 92, and we adopt all his submissions in that regard. I only hope in the few short minutes that I have to consider or to bring to your consideration some rather more practical aspects of the construction argued for by the respondents. We are speaking here, are we not, about the grey market. That's a useful shorthand term with which to describe the construction that the appellants place upon the section, namely that Section 92 is not intended to make criminal or to criminalise the trade in the grey market. The simple fact is that this Act has been in force for 22 years. There have been no prosecutions, let alone convictions, of traders indulging in the grey market. And whilst I quite accept that this court is unlikely to take as a guide the views of construction of trading standard officers up and down the country over the simple construction of the section, the fact is that the respondents' construction of the section would mean that the country as a whole has been operating under a misapprehension as to the meaning of Section 92 for the last 22 years. The grey market is not just in clothing, as in this case.
No.
It ranges from anything from pharmaceuticals to motor cars. That there is a perfectly legitimate market in the grey market. Yes. Such trade can take place without harm either to the trademark holder or to the public.
So when you say legitimate, you mean, yes, I'm sorry, you're going to say no harm done to the trademark holder either?
Yes, for instance, if, for instance, a trademark holder does manufacture and apply his trademark to goods, and subsequently those goods are sold in the United Kingdom by a trader without the consent of the trademark holder on the respondent's construction, that would be a criminal offence visitable with 10 years imprisonment. The only reason why it would be criminal is because the consent of the trademark holder had not been obtained.
Why is that a surprising or disgraceful state of affairs?
I'm not suggesting it is. I'm merely saying that it would be the state of affairs. There is a legitimate market, save for...
You've only to ask, haven't
It's
you?
only legitimate, depending on what the Act says, isn't it?
Well, can I take
About the Act, then it's legitimate.
an example that was raised earlier?
It would be legitimate in civil law, on any view.
No.
Yes, I'm talking about criminally legitimate. Your Lordship referred earlier to the situation where goods have been manufactured and they have not come up to the standard required by the trademark holder. And that on the appellant's construction, those would not be caught by the Act. But we say it's right that such items should not be caught by the Act. There is a perfectly legitimate trade in seconds. That is to say, where the trademark holder sells into the market goods which are...
Those are the ones that are sold marked seconds.
Yes, yes. And if they're not marked seconds, it would be an offence contrary to the Fraud Act.
But even if they are marked seconds, as I understand it, the law is that it's still an offence. If you take the counterfeiting provision in A, it's still an offence to do it, even though the trader says they're not real, but they're good.
genuine fakes.
Well, high quality fakes.
Yes, they may or may not be high quality.
Yes.
This was the very thing that was
If you tell
referred to
people
by...
they're fakes when they buy them, you're still committing the offence, as I understand the case law.
Your Lordship is referring to genuine fakes referred to by Lord Nichols in paragraph 26.
Well, I'm also referring to cases referred to in, I think, Curley, where
Yes.
people have been convicted in precisely those circumstances, and the words used by the stallholder were, they're not real, but they're good.
Yes, but may I make this point about that? The whole point about genuine fakes is that they are, by definition, counterfeit. Indeed, it was said by Lord Nichols that that was the reason for the changing of the bill to the, in clause 86, to the terms of section 92, was in order to deal with the problem of genuine fakes. Genuine fakes are counterfeit.
I mean, I absolutely understand why there can be, as you say, a legitimate market in seconds. But given that, first of all, it's unlawful civilly to sell them, and secondly, you've only got to ask, where is the harm done? Why is the what you call the overreach of this section so damaging?
Well, can I put it this way? You say that Your Lordship has indicated that to sell them without consent would be a civil infringement.
It would, wouldn't it?
Of course, it wouldn't be a civil infringement if the goods had been placed on the market within the EEA, the European Economic Area, because the exhaustion of rights occurs.
Yes, second-hand.
Can I make this point about Section 12? Could I take Your Lordships to Section 12? Because there is a curious point to be made in relation to Section 12, the answer to which I'm not sure that I know.
Page?
It is on page, it's behind tab 1B, and it is page 182.
Yep, thank you. So we're looking at section 12.
Yes, exhaustion.
A registered trademark is not infringed by the use of the trademark.
Yes, in relation to goods.
So that is not a registered trademark is not infringed by the use of a sign identical to or likely to be mistaken for. Yeah. Thus it is that if a manufacturer if a trademark holder manufactures goods which bear a sign which is identical to or likely to be mistaken for, but which is not the registered trademark, then anonymously his rights are not exhausted.
Sorry, which is not the registered trademark. What do you mean by that?
Well, let me
If
take
it's
a
identical
practical example.
If it's identical to the registered trademark, it is the registered trademark.
No, if Levi jeans, Levi Strauss, were to manufacture in Europe a pair of jeans, and instead of placing on the rear of the jeans their registered trademark, they apply a sign which merely is likely to be mistaken for the Levi Strauss trademark, as indeed Mr. Justice Burrs adverted as occasionally occurring. Such a sign would not be the trademark. Section 12 allows for the exhaustion of rights only where the use is made of the trademark, that is to say, the registered trademark.
Yes,
now, as I say, I don't confess to knowing the answer to that. But what it does...
Wouldn't a liberal construction would suggest that they are using their trademark if they get it slightly wrong in a way which is likely to be mistaken.
You're more interested in the one which isn't the Ralph Lauren sign, but says something else like Lauren in a funny place.
Yes.
Yes, that sort of situation. Yes, I see.
What we submit is what can be gleaned from this is that the civil provisions are entirely separate to the criminal provisions. We already know that the two different prepositions are used in respect of each area. And that is no more than an indication of the different derivation between them. Johnston, of course, makes it necessary that before the criminal offence there should be an infringement. But what Johnston does not say is that an infringement is sufficient.
No, that's the question here.
Indeed,
well, nobody thinks that it's necessarily sufficient, do they, because of the statutory defence?
yes. Can I just very briefly say something about the statutory defence? The statutory defence, it must be remembered, is one where the burden of proof is reversed. The respondent has indicated that by their construction, it is true that Tesco stores would have committed or at least there would be grounds to prosecute them for having committed a very serious criminal offence, contrary to Section 92, if their construction of Section 92 is correct. Indeed, the position would be that if this court decided that Section 92 was to be constructed in the way that the respondent submits, arrests of Tesco's directors could take place, no doubt, tomorrow. So the fact that there is a defence under subsection 5, which is relied upon by the respondents to justify that extraordinary state of affairs, is, we respectfully submit, useless. We say, as indeed Mr. Blacksman has submitted, that the expression "such a sign" in subsection in paragraph B must refer to a sign applied without consent, because otherwise it does not make sense of the decision of the House of Lords in Johnston. Could I take your lordship just to one other reference in Johnston, beyond paragraphs 26 and 59, and it is paragraph 88. And that's at page 291 of the first volume. I read from about halfway through paragraph 88. It is adequately, if not pollucedly, expressed in the language of Section 92, which in its 3 offence-creating subsections requires the defendant, for the purpose of gain, to have applied a sign to goods or their packaging, or to have engaged in other acts or conduct in relation to goods or business materials which bear that sign.
Seems to raise the same point as
it does.
We have to consider in this case.
Yeah, restates it.
Yes. Yes.
We have set out in our statement of case our submissions in relation to the principle of consequential construction. I don't propose to read those to your lordships, of course, now. We say that the effect of the respondent's construction would make a highly anomalous situation. Mr. Blacksland and Mr. Henry refer in their submissions to the situation of a genuine article manufactured in Thailand. One can bring it very much closer to home. On the prosecution respondent's construction of Section 92, if goods were manufactured in Slovakia, which is a member of the European Economic Area, and the trademark applied in that country with the consent of the trademark holder and sold into the market by the trademark holder, the subsequent sale of such goods in the United Kingdom would not be an offence under Section 92. If the very same goods were constructed or manufactured in Switzerland, which is not a member of the European Economic Area, on the respondent's construction, a criminal offence visitable with 10 years imprisonment would have been committed. my Lord, unless I think I have overstepped our timing.
No, we started at 11. And you've indented for an hour and a quarter between you.
No, we were only indented for an hour, I fear.
Oh, and 15 minutes in reply. You're quite right. Very well. Well, allowing for 1 minute silence, it's de minimis.
Thank you.
Thank you very much.
Yes, sir.
Mr. Blacksland is going to give... No, we're not. Thank you very
thank
much. Mr. Baker. Thank you. Mr. Christopher.
These, Your Lordships. My Lord, our submission is quite simply that section 92(1) means what it says. And that the fact that the words without the consent of the proprietor come before paragraphs A, B, and C mean that they apply equally to each without being rolled up within paragraph A by the time one gets to paragraph B. And we submit that the draftsman would indeed have used a mechanism such as referring in paragraph B, instead of using the words such a sign, would have said something like, which bears a sign applied in contravention of paragraph A, using the same sort of mechanism as we can see, as my Lord has indicated, in paragraph C. It's an artificial construction, in our respectful submission, to seek to import the lack of consent within the meaning of such a sign, when the consent is in fact nothing about the sign at all. It's about the way that it was applied, or the circumstances in which it was applied. So it would at the very least be necessary to say such a sign so applied, for example. And secondly, in our respectful submission, there's no good cause for seeking such an artificial construction of section 92, because there is no reason to think that Parliament did not intend to cover the variety of grey goods, in other words, goods that are sold without the consent of the trademark proprietor within the ambit of section 92. My Lords, there's been an argument put forward which is a new development. I wonder if I could address it, if it would be convenient to do so at this stage, because it said that if the respondent's construction is correct, this is an inadvertent consequence of the amendment of the previous Act in order to remove the mens rea, and that if Parliament, by phrasing section 92 as it did, has widened the ambit, that was by mistake. In our respectful submission, that is a flawed proposition, because the previous Act, in exactly the same way, applied to grey goods just as it did to counterfeit goods, and the amendment cannot have had that effect. And I wonder if I could just elaborate on that submission by asking your Lordships to turn to section 58A, which is in volume 1 of the authorities at page 187.
Yeah. Yep.
And if I could observe first that the format is very similar, so that under subsection 1 it's an offence subject to subsection 3 below for a person A to apply a mark identical to or nearly resembling a registered trademark to goods, etc. And then B, to sell, let for hire, or offer or expose for sale or hire or distribute goods bearing such a mark, or 2, material bearing such a mark.
I see, and then you get when not entitled. So it's mark rather than sign, and when not entitled at the end of the 4 paragraphs, rather than without the consent of the proprietor at the beginning of the 3 paragraphs.
Yes, absolutely. So
You say it's the same point.
It's the same point, but then the suggestion is that it was the amendment from section 58A which widened the ambit of the offence.
Well, I think the suggestion is that it's the abolition of the mens rea,
my Lord,
which wasn't in 58A, was it? It was in, well, it was in 58A subsection 3, wasn't it?
Indeed, my Lord.
Yep.
So if one looks at subsection 3, a person commits an offence under subsection 1 or 2 only if A, he acts with a view to gain for himself or another, or with intent to cause loss to another, and then B is the paragraph in point. He intends that the goods in question should be accepted as connected in the course of trade with a person entitled to use the mark in question. And so that produced the problem of a trader who says these are fake but they're good. But it catches in exactly the same way a trader who is unlawfully, in a civil sense, selling grey goods, such as goods that have been rejected as being defective in quality, for example, because such a trader also intends that the goods in question should be accepted as connected in the course of trade with the person entitled to use the mark in question.
Yes, I see.
So there was nothing about that aspect of the mens rea that was specific to counterfeiting, and removing it didn't let in any categories of goods that weren't there before.
Yep.
My Lord, can I address the question of Article 1, Protocol 1, just simply to add one other observation?
Yes.
I'm sure the court is very familiar with it, but the article is set out.
I think we are, yes.
I'm most grateful. It's the second paragraph that I wish to draw your lordship's attention to, in addition to the point that has been made by my lords already as to the ambit of the property right. The qualification to A1P1 is, it's at page 385.
Thank you.
385.
Yep. Yep.
The preceding provisions shall not, however, in any way impair the right of a state to enforce such laws as it deems necessary to control the use of property in accordance with the general interest, or to secure the payment of taxes or other contributions or penalties. So there's a distinction between depriving someone of the property and limiting their use. And Section 92, particularly Section 92(1)(b), is aimed at limiting the use that can be made of infringing goods.
Yep.
It's been said by my learned friends that there is a perfectly legitimate market in grey goods. We would respectfully take issue with that. And a market which is unlawful as being contrary to the civil law cannot properly, in our submission, be described as being perfectly legitimate.
Well, anyway, the argument is circular, even if you confine it to the criminal law.
Yeah, indeed. Yes, my lord.
Do you want? Do you agree with the proposition which is put to us, whether it's material or not, that nobody actually has been prosecuted under this Act in the previous 20 years?
I can't produce a counterexample. I'm unaware of a...
Has there been any kind of discussion, public discussion, of the rights and wrongs of doing so?
Not so far as I'm aware.
Just hasn't happened.
Individual trading standards authorities have their own guidance and policy.
Does the guidance, any of the guidance, cast light on this point that's an issue in this case?
Typically, it indicates that cases will be assessed on their particular merits.
Right, well, that's very helpful. Is there any help in any of the guidance on the point at issue in this case?
No.
I mean, perhaps one shouldn't ask, but is there any particular reason why this case has happened now?
Well,
Again, don't answer that. If that's, I see we're concerned with
maybe
batches of shipping containers.
we're concerned with very large quantities.
I was going to say they look like quite large quantities. Yeah.
Yes. Multiple wholesale quantities outside the ambit of your average trading standards prosecution. And indeed, this is not a trading standards
That's what I was.
prosecution.
It's not.
It's not. It's a police prosecution, a CPS prosecution.
I see.
But as for the understanding up and down the country, there's no issue taken with the contention that certainly the textbook, Curley, proceeds on the basis that grey goods are included within the ambit of Section 92, without any doubts on the matter being expressed. Lords, I think I've dealt with all the new points which have arisen and our arguments as to the difficulty that would be presented even in the prosecution of counterfeits if the appellant's construction were right are summarised in the respondent's case. Can I avert to one of them in particular, the question of deliberate overruns, where a manufacturer deliberately produces twice as many as they've been asked to, and it appears to be conceded by my learned friends that half of those will be counterfeit and half will not.
How does one know which half?
Well, my lord, precisely, indeed, in my submission, it's not simply a question of proof. There is no meaningful answer to which half, because there's no difference between one half and the other half. There's no basis for saying, well, they would fulfill the order first and do the extras afterwards so that it would be in time.
What actually happens? I mean, in practice, they manufacture, say they're asked to produce 1,000 articles and they manufacture 2,000.
So they then sell 1,000, well, they sell 1,000 to the trademark proprietor in accordance with their contract, and they sell the other 1,000 out of the side door, cut price, entirely for their own benefit.
So it's obvious which category a particular item falls.
Well, my lord,
after it's been disposed of.
Well,
is that not right?
Well, if my learned friends are right, and the key point is not the point of sale, but the point of the application, then there would seem to be no reason why they couldn't turn around and say, well, actually, we gave the trademark proprietor the extra ones, and we sold the genuine ones through the side door. Because the...
Wouldn't they say they were all okay?
They were all...
Well, no,
they're all genuine.
They're all genuine.
Well...
but I mean, your point is that if they're all genuine, you need an extra offence for selling them without authority.
Absolutely.
Whereas in your case, it's easy. The first 1,000 that have been provided the trademark proprietor are okay, and the other ones that have gone out the back door are not, and are susceptible to falling within B and C, subject to the defence of reasonable belief.
Absolutely. Yes. Yeah. And so there's a similar situation which is a question of proof, where a manufacturer's authorization is revoked, as frequently happens if they continue making the goods and selling them entirely for their own benefit. Then the prosecution has to prove the precise date of manufacture. And by definition, we're dealing with a circumstance where there isn't this sort of audit trail that would enable the prosecution to pin a precise time and place of manufacture on these goods.
Well, the problem, I can see that the problem would arise if your manufacturer sold the whole lot to somebody such as the present defendants. But if they did sell some back to the trademark owner, or supplied them back to the trade, they're making them under license and giving them back to the trademark holder, then it is just a question of tracing whether they've come out of the front door or the side door, isn't it?
It is just a question of that, yes.
I appreciate sometimes you can't do it, but it's not solved by either of these constructions, is it? It's the same problem in both cases.
Yes. Yes, it is. Yes, yeah. Accept that. Yes. And then we have the additional problem that the appellant's construction makes it all the harder to prosecute the better the counterfeit is. Because if it is a counterfeit, if it's very like the genuine article, then it's easier for the trader to say, well, actually, this is grey goods.
Well, that's true, whoever's right, isn't
Yes,
it?
exactly.
And it's a problem you've got under the statutory
Well,
defence anyway.
if it may well be that a trademark proprietor, as happens in some instances in this case, can say, well, we received all the goods. We put in an order for 1,000 and we received 1,000.
Yeah.
And these ones you're showing us now are not that 1,000. And that would be enough to establish that they are grey goods or counterfeit. And it wouldn't matter, the prosecution wouldn't turn on which they were.
But the better the goods, the easier it is for the defendant to run the statutory defence.
Yes.
Surely.
Yes. Yes.
These are so good, they fooled me. It arises, doesn't it, in any event? Problem.
Well, these are so good they fooled me would not be a reason for concluding that they were not overruns, that they were not grey goods in the various different ways.
I see.
It would not be a reason for concluding that they were not infringing.
It all depends on all the other circumstances, doesn't it?
Absolutely,
Yeah.
yes.
But certainly if it was obviously a crude version, that would not be a good start for the defendant.
No. But if it was a manufacturer who says, there's no way we would have authorised the sale of this because the stitching is wrong, it's not our stitching, does the prosecution have to prove that that's not because an authorised factory got it wrong and therefore it was rejected, rather than a different factory didn't quite get it right? It presents difficulties when the simple fact is that the trademark proprietor did not authorise the sale of substandard goods. Their being sold on the market undervalues the brand and enables other people to benefit from the investment that the trademark proprietor has put in.
Yes.
And there's nothing perverse in our respectful submission by the application of criminal sanctions. Unless there are any particular points on which I can assist your lordships, those are my submissions.
Thank you, Mr. Christopher. Thank you.
Oh, do you want to say anything, Mr. Christopher, about the EEA, the Slovakia-Switzerland conundrum, or not?
That is, just in another form, the Levi-Tesco conundrum.
Right.
It's being presented as, it's another form of the parallel trader.
Just one of those things. Just one of those
It's
things.
a consequence of European Union or
It
the
is.
EEA.
It is.
Nothing more.
It's the consequence, absolutely, of
EEA.
Fortress
Yeah.
Europe.
So it happens anyway.
Yes.
Got it.
And if it was a one-off sale by a holidaymaker, then it wouldn't be in the course of trade and wouldn't be a civil infringement. If, on the other hand, it's a calculated move by a trader importing shipping containers, knowing that that's contrary to the civil law, that's a very different matter.
Thank you, Mr. Christopher. Mr. Nicholson. Blackson.
Yes, very briefly, just three points in reply, if I might. Could I just go back to the point about the original section, which is section 58A,
Yes, of
which
course.
is in volume 1 of the authorities bundle at page 187.
Thank you.
Behind tab 2.
Yes.
Just 2 points, really. One is that as my Lord Newberger pointed out, the governing provision comes at the end of the first subsection, in contradistinction to section 92. So section 58A starts off by identifying the particular conduct which is all subject to, at the end of the section, the lack of entitlement to use the mark. But it may have been put back to front, but it has, in our submission, the same effect, and it doesn't derogate or just from the point that we made. In relation to the mens rea element and the removal of the mens rea element, on the Crown submission, if the Crown are right, and in fact that mens rea element added nothing, then I would submit all the more reason to construe the section in the way that we advocate. But on the face of it, subsection 3b did introduce, although it doesn't use the word dishonesty, it did in fact introduce an element of deception.
Well, yes, but I don't think it's said against you that it added nothing. They just say that
we'd still be caught.
As drafted would still catch the grey goods.
We'd still be caught. Well, that's, in my submission, would be subject to further consideration. The intention is that the goods in question should be accepted as connected in the course of trade with the person entitled to use the mark in question. Because it focuses on the intention that the person who is buying the goods will accept that they are the real thing, essentially. That's the point of this subsection. That is arguably what provided that section 58A was confined to counterfeit goods. And there is no doubt that in the parliamentary debates, Parliament thought that the section was intended to prohibit the trade in counterfeit goods. There is absolutely no doubt of that from reading the parliamentary debates. And it may well be that that's what was achieved by the subsection. It may be, inadvertently, that the problem has been created. If that is right, then one has to look at the construction that we say should properly be put on section 92 in order to give it the intention which we say Parliament intended for it. And then the second point is in relation to the issue which arose for discussion about the policy in relation to prosecution of grey goods. We have included in the bundle, as the Court may recall, at behind tab 10, page 222, the regulation in relation to the enforcement of these provisions, and we simply draw the Court's attention at page 223 to the distinction which is drawn between infringements which arise in relation, we would submit to the trade in counterfeit goods as opposed to the trade to the illegal parallel trade and the lack of prosecution. So to the extent that the Court is interested in policy considerations, one does find some support for that. And it may well be that, in fact, the policy of prosecution has really focused principally on protection of the consumer as opposed to protection of the trader. And that is quite an important point, because if what is occurring here is a construction of the section which focuses to a significant extent on the economic rights of the trader, they are adequately protected by the civil law in our respectful submission. As construed in the cases of S and Johnston, it's my submission that the protection of the trader in section 92 is confined to the protection of the trader from the trade in counterfeit goods, because that devalues the brand, and it should be limited to that. Well, those are my points in reply, unless there are any other matters.
Thank you very much. Thank you. Mr. Bromley Martin.
My Lord, on that last point, the policy considerations, My Lords, from the witness statements that have been served by the prosecution in this case, and indeed from our general knowledge of the practical situation, it is apparent that trading standards departments and indeed prosecuting authorities across the country make the distinction between, on the one hand, counterfeit goods and on the other hand, genuine goods. And those are the two expressions that are generally used. And that goods in the grey market are by definition genuine because they have been manufactured and the sign applied by the trademark holder.
That may be an explanation of why trading standards officers haven't prosecuted, because the consumer isn't harmed. But it's not a very useful point for the construction of the Act.
Well, my Lord, I said that earlier, didn't I? That it may be that this court does not wish to have instruction on the construction of Section 92 from various trading standards departments across the country. I accept that.
Well, this European Union legislation we were referred to from 2013 suggests that the Commission and the Council have concentrated on counterfeit in the sense you're using it.
Yes, indeed.
And
yes.
Deliberately excluded grey goods, so that may be another reason why the attitude is taken by the authorities you mentioned.
Indeed. My Lord, secondly, this, we submit that it is not of assistance to this court for the construction of what is a penal statute that to apply a particular construction would make it more difficult to prosecute. We submit that that is an inappropriate submission to make. In any event, in the example given, as your lordships have observed, it makes no difference. On the prosecution or the respondent's construction, it would still be necessary to prove that the trademark holder had not given consent to their sale.
In fairness to Mr. Christopher, I think you say it's an inappropriate submission for us to accept.
That is a better way of putting it, my Lord, as ever.
Well, thank you. Yep, sorry, we got another point.
My Lord, in relation to the Slovakia-Switzerland question, I hesitate to involve any question of Brexit. But if the United Kingdom were to withdraw from the European Economic Area, that would overnight turn what was done yesterday as a legitimate market and wholly legitimate trade in the goods concerned into a criminal offence contrary to Section 92. Or indeed, more significantly, if Switzerland were to join.
Well, it no doubt create lots of potential civil liability as well.
Well, exactly.
I suspect there may be one or two transitional provisions that might be considered, but we wait to see.
There are one or two, my Lord. Indeed, there are.
Yes.
It may not be right at the head of the government's list of concerns.
Well, I think for the time being, everything will remain the same. Very well.
That is true, although who knows what Switzerland might do. Or indeed Slovakia, for that matter. My Lords, there was submissions made in the respondent's statement of case relating to the comparison with subsection 92, subsection 2. Mr. Christopher did not address them in addition orally, but I do have a response to his paragraph 7 and 8. Would it be of assistance to the court if I gave it?
If you feel you should do so, then you should do so.
Well, my Lord, turning then to those paragraphs, which are on page 120 in the core bundle.
Thank you. Yes.
And section 92, subsection 2, of
Yes.
course, is on page 177 of the
Yes.
first volume.
We've also got it here in the statement of case. But anyway, yep.
In what is,
It's the same point.
we concede, is a superficially attractive argument,
Yes.
we say is flawed. In paragraph 8, the respondent submits that applying the appellant's construction of subsection B to the equivalent words in 92.2b
Yes.
would produce the undesirable result that whilst use of counterfeit labels or packaging would be an offence, the use of genuine branded labels or packaging for counterfeit or unbranded goods would not.
Yes.
That is not the case. Paragraph 92.1b provides that a person who sells, etc., goods which bear or the packaging of which bears such a sign.
Yes.
So the use of genuine branded labels or packaging for counterfeit or for counterfeit goods would be a breach of section 92.1b. If, on the other hand, the use was of genuine branded packaging for unbranded goods, we submit that in those circumstances that can either be fraudulent or non-fraudulent. So, for instance, if someone had a completely unbranded T-shirt, yes, and the only packets that they had to hand over to the customer were, I don't know, a Gucci bag, and it's placed into the Gucci bag for that reason, that would clearly not be fraudulent, and heaven forbid that anyone should be prosecuted for that. If, of course, the person was selling unbranded goods in a Gucci bag because what they were trying to suggest to the purchaser was that they were Gucci T-shirts, then that would be a simple offence of fraud, easily dealt with by current legislation. Those are my submissions in relation to those two paragraphs.
Yes,
you are not assisted, in other words, by a comparison with 92.2b.
Mr. Christopher, you didn't develop your argument on this. Given that Mr. Bromley-Martin's picked it up, I don't have anything you want to say about it.
I don't think I need to, my lord. The reason I didn't was because my learned friend, Mr. Blaxland, accepted the respondent's construction. But in fact, I take my learned friend, Mr. Bromley-Martin, to be accepting the consequences as well. And each of them says, well, it would be covered by fraud. The response to that is that Parliament, dealing with the criminal offences under the Trademarks Act, might be thought to have been intending to deal with it under those provisions, which would be the natural thing to do.
Thank you very much.
My lord, might I just indicate one other thing,
yes,
in case it assists, which is the trial date for this case is currently the 23rd of October of this year.
We'll take that point on board. Thank you very much.
I'm most grateful.
My lord, forgive me.
In terms of preparation to trial and so on, realistically, when would you need to know?
Well, this decision will have probably a large impact on.
That's why I asked.
And so, if it were possible to know by the end of this term, that would be of great convenience.
Thank you. Sorry. Thank you very much, Mr. Christopher. Yes, you wanted to say something, Mr. Bromley-Martin.
My lord, forgive me, just on that last
yes,
subsection 2 point.
Yes,
it's not merely that a person who places counterfeit goods, unbranded goods, in a genuine packaging, who can be prosecuted for fraud if that is fraudulent. What the effect of the respondent's construction of section 92 would be that if a trader, a market trader, places unbranded goods quite innocently in a Gucci bag, he would be liable to prosecution under section 92.2b.
Thank you. Well, we're grateful to Mr. Blackstone, Mr. Bromley-Martin, Mr. Christopher for their oral submissions and for making them concisely and clearly. We're grateful also to all those who were involved in preparing the written cases. We will consider this matter and let you know our decision in due course. We understand the need, if possible, for communication of the decision before the end of July. And if we don't have our decision formally handed down by then, I very much hope and indeed expect that we will be able to communicate our decision so the parties know the position. Thank you all very much indeed. The court's now adjourned.